Good morning and a warm welcome to everyone. My name is George and I'm a corporate paralegal at Fichte & Co. and I will be moderating today's webinar session. For those who are new to our webinar, thank you for joining us today, and for those who are back again, welcome back. As always, I hope that you're all doing fine and staying safe. As we are aware, the real estate market has been one of the major economic drivers in the region for a number of years, and one that has taken a hit due to the pandemic. And as the coronavirus outbreak continues to affect the real estate market in the UAE, there has been various legal impacts faced by the industry. And such factors will be contingent on how long the economy takes back to get on track. On that note, we have received a number of questions surrounding the impact of the coronavirus outbreak on the real estate sector. Hence, we decided to conduct a webinar today which will be focusing on the major legal issues surrounding the industry, the obstacles, the opportunities, and more importantly, to address the issues that you may have, by taking in live questions after the presentations in order for our experts to answer your queries. Please do note that this webinar is only for an hour, so we will try our best to get through as many questions as possible. The presentation will be split into two segments. The first half from 11 to 11:15, which will be conducted by and Commercial Senior Associate Dr. Laura Botta, discussing off-plan sales and purchase and rental disputes from a corporate perspective. And the second segment will be conducted by our litigation associate, Mahmoud Ahmed, discussing the legal issues surrounding real estate from a litigation perspective, between 11:15 to 11:30, followed by our final segment, which is a live Q&A between 11:30 to 12 p.m. So without any further delay, Dr. Laura Botta, if I may pass the screen on to you to begin the presentation.
Good morning, everyone. Thank you, Ifra, for your warm words and for the introduction. Thank you all for joining us today. Today we are touching a topic which is, I believe, of interest for many of us. The impact of the current pandemic on the real estate market, and it's not random that we are focusing our today's webinar on two main aspects. One of them being the off-plan sales and purchase, and the other one being the lease agreements that have been somehow impacted by this situation. As Ifra was saying in the beginning, we hope that these disruptions are short-lived, and our focus of today is nevertheless a purely legal one. We are not real estate specialists to predict trends in the market, but we can predict legal risks and the way in which us as lawyers can advise our clients to alleviate or to mitigate these risks. So from a purely contractual perspective, the pandemic obviously is a disruptor. It affected the capacity of an investor to produce liquidity and to allocate it into investments. But at the same time, even if the preventive measures did not affect as such the construction sector, disruptions exist there as well. Now, everyone knows that in here, the off-plan sales and purchase is a sensitive domain, because as long as the developer cannot generate sufficient liquidity to use it for the project may be delayed or at the later stage even stalled. So the first question that comes into the mind of a legal professional is whether this is a case of force majeure or, on the contrary, it is something else. The answer to this question is not that simple, because as per the UAE Civil Code, a case of force majeure is a case that makes the performance of the contract impossible, and it's of strict application and interpretation according to the jurisprudence of the Court of Cassation. So we remember cases that have been dealt with by the Dubai Court of Cassation in 2011, stating clearly that this extraneous event outside the power of control of a contracting party needs to be strong enough, needs to be persistent enough, and needs to be, let's say, lengthy enough in order to justify a proper qualification of that event as force majeure. As of now, since things are quite recent, we have very little jurisprudence seeing on how courts look into the pandemics in the off-plan sales and purchase. But we can estimate that from our point of view as lawyers, it is more reasonable to believe that the current pandemic constitutes more an event of hardship, an event of, let's say, of realigning or allowing the parties to realign the obligations that they have contracting according to, say, an SPA, which is slightly different, because when you discuss about force majeure, the contract is lacking in effects for the future, whereas when we are discussing about hardship, the contract or the SPA at issue would continue to be performed, but the balance of obligations in between, let's say, the developer and the buyer is going to be rescheduled. In simple terms, either the developer would get some lenience, either the buyer would get some lenience, or even both. From a business perspective, obviously, we would need to highlight a very important point, namely that it is easy to deal with things in a negotiation perspective. However, given the fact that the market, or especially the off-plan sales and purchase market, is highly regulated, the chance that a developer and an off-plan buyer to come to better terms together are quite limited, not impossible, but quite limited. In order to address this situation, we know very well that from the beginning of the preventive measures in March, the central bank has issued a targeted economic support scheme and allocated an aid for the commercial banks, ranking somewhere at around 100 billion dirhams, against obviously securities collaterals from the said banks. But this impacted as well the real estate sector, because the central bank made clear directives that the down payment to be covered by an investor would rank lower, and at the same time, the exposure of a financial institution to loans can increase to 20 to 30%. So this is an important stimulus for the real estate sector. But given that we have this new tool at hand, yeah, we would need to translate that properly into contracts. Now, moving forward to our next slide, yeah, we would like to carry on with this discussion and look into the contractual consequences, which are very visible in off-plan sales and purchase of properties. So, to repeat ourselves, if allowed, whereas we have little jurisprudence available, we have seen from the advisory opinions and different litigation cases that we have carried on behalf of our clients that in general developers are less inclined to offer lenience with the payments. From one part of this picture, it is clearly understood, because in the eyes of a governmental regulatory authority, since the real estate sector has not been impacted as such by the precautionary measures, and to be more precise, the construction sector, it is unlikely that a developer would have, let's say, better terms or more lenient terms when it comes to direct damages to the buyers, or indirect damages caused to those buyers by the relationship with the contractors, with subcontractors, etc. So the off-plan sales and purchase is a full spectrum that we would need to analyze, and the analyze tends to be comprehensive. Now, whether the situation can be used by the developers as an inflation hedge, this is very early to assess as of now. We do not have, as said, sufficient jurisprudence available, but at the same time, the developer has some tools at hand in order to deal with, let's say, lack of liquidity in the projects, when this lack of liquidity is generated by the lack of investment on the part of a buyer. Yeah. And moving forward to our presentation, we are highlighting here two main points that we believe that anyone activating or investing in the off-plan sales and purchase market should know. Given that the developer may face disbalance and delays in completing the project, as said, due to lack of funds in the escrow account, the regulator here in Dubai, the DLD, has granted, or the RERA has granted the developers a specific procedure issued by Law 19 of 2007 in amendment of Article 11 of Law 13 of 2008, which actually states that a developer may terminate and deregister an off-plan property, even if they don't have a court decision or an arbitral award at hand. And this is just to protect both the developer for completing the property, but at the same time to ensure a certain standard in the market, a certain standard of, let's say, quality, a certain standard of quality of deadlines, and in the future or for the future to be able to attract more investment in consideration of the fact that this market, the local market, is reliable. So it's for everyone to know that whereas a developer doesn't have to obtain a court order or a arbitral award in order to terminate an SPA for an off-plan property, there are certain thresholds that are issued by law number 19, which are as follows. If the completion status of a property exceeds 80% and the investor stops making payments, then the developer has the option to ask for the execution of the contract, or which is probably the most appropriate path for the developer, or to terminate this SPA unilaterally and retain 40% of the purchase price as penalty. Needless to mention, the provisions of the law constitute public order. Therefore, any provision to the contrary inserted by the buyer and the developer in the SPA would be null and void. Again, if the completion status ranks in between 60 and 80%, again, the developer has the right to terminate the contract at a penalty of 40% of the purchase price. And then the thresholds go lower. For instance, if the completion status is below 60%, then the developer has the right to retain 20%, 25% of the purchase price. And we have here a fourth case where the developer has not started the construction for events not imputable to them. For example, lack of approvals, lack of governmental, let's say, approvals, lack of, let's say, being provided with the land, etc. So for all these situations where the developer did not start the construction for reasons not imputable to them, the termination comes at a penalty of 30% for the buyer from the amounts that the buyer has paid. So with this in hand, the situation is not always rosy for the developers, because moving forward to probably the next point in my presentation, an inherent natural question is whether, okay, what if a project is being so impacted that it is stalled or cancelled? So at that point, we would need to know very well that we have an Executive Council resolution in here that deals clearly with these situations, and which says that the cancellation of a real estate project cannot be determined by the developer nor by the buyer, but on the contrary by a governmental authority, which is RERA. And then RERA has a specific procedure in order to, let's say, declare a project as stalled. What is important for the investors in this situation is that when the RERA would cancel a project, they would be returned all the amounts paid from the escrow account. And according to this Executive Council resolution, in case the developer is in shortfall, he is being granted a 60 days period in order to cover this shortfall in the escrow account, which counts to an additional, let's say, protection for the investors. Now, if it is for us to move forward to the conclusive remarks, for these topics, if we can move please to the next slide. Can we use the current situation as a reason for justifying delays on the part of the developer? It is very unlikely that the developer has this option in the current situation. Probably, anyway, the developers issue contracts which allow a margin in between the anticipated completion date and the actual completion date of that project. However, as of now, there is no, let's say, government or regulation in the Emirate of Dubai allowing precisely or exclusively such a delay on the part of the developer. We would say that for each and every investor, they need to be aware that the completion of the project is attested with the building completion certificate issued by the municipality. And at all times, the contracts or the SPAs used in off-plan real estate sales and purchases would need to be carefully studied prior to entering into such agreements, because as clear as these SPAs are, or as unclear, it depends on how each and every investor sees them, or it depends whether they carry legal advice on them or not. It is for us important to highlight that in reality, when we are suing a developer allegedly for a delay, this is not necessarily a delay, because the courts have a rich jurisprudence stating that a developer is not always in delay just because the completion deadline is not as stated in the contract. So as strange or as unusual as this situation may look, a court would not automatically terminate an SPA and grant allegedly penalties to a buyer just because the property is not completed on the date stated in the SPA. With this in mind, from our point of view as lawyers, we would, let's say, emphasize on the need of having contracts properly made in light of the current situation, especially the force majeure and delays clause, which we can do for our clients, and we are currently doing. And to move forward to our presentation for today, we would need to look into a second topic, which is equally interesting. And it pertains to the lease agreements, which are very common, and the problems associated with them are very common in the market. And for this, it is my pleasure to pass it on to our colleague and litigator, Mr. Mahmoud. Mahmoud, you have the floor.
Hi, good morning, everyone. Thank you, Laura, and thank you, Efra, for your introduction. At this part of webinar, we will speak about the impact of the coronavirus in the real estate dispute, especially in tenancy contract and the relation between the landlords and the tenants. It's most important to have the exact definition of force majeures. So the force majeure is a common clause in the contract that frees both parts from the liability or the obligation when an extraordinary event or circumstances beyond the contract of the both parties. We can have examples for this, such as war, strikes, epidemic, also the natural disaster, such as tornado or earthquake. It can be kind of the force majeure. We are described this legally by the act of gods, so no one can anticipate that this circumstances will be happen, and no one can force it. And since the World Health Organization has classified the coronavirus as a global pandemic, so coronavirus is considered as a force majeure. This is the exact definition of the force majeure, and in order to speak about the relation between the landlord and the tenant, we should move to the other point and other articles in the Civil Transaction Law, which is applied also on the tenancy contract, because the tenancy contract is a type of contracts binding on both parties. So the general condition of the contracts which mentioned in the Civil Transaction Law applied on it. The most important two articles which we want to mention in our webinar today is both article. One is discussing the exceptional circumstances, and the other one is discussing the force majeure. The first article, number 249, which discussing the exceptional circumstances. This exceptional circumstances should be with a public nature, not exceptional circumstances for personally for one, such as he lost his job or he get divorced in some way or other any personal circumstances. No, the article was very clear. This exceptional circumstances should be with a public nature, which could not have been foreseen, and as a result of this circumstances, the performance of the contract obligation between the parties became impossible or oppressive to any of the parties. In this case, these parts may have a grave loss to comply and fulfill the contract obligations. So, in these articles, the law gives the judge the right, after studying all the circumstances, to reduce the observed obligation or to reduce it to the reasonable level. The other articles, number 273, which is discussing the force majeure, is discussing the performance of the contract during this exceptional circumstances is impossible, so the obligation shall be ceased and the contract shall be automatically cancelled. And also this should be through a court order or court judgment. Then, according to these articles, which is applied to all the contract binding on both parties, also it's applied to the tenancy contract, we can move then to the rental dispute center proceedings, because during this corona pandemic, a lot of issues and a lot of problems raised between the landlords and between the tenant as well. So the law number 26 of 2007, which make the regulation in the relation between the landlords and the tenancy, which amended by law number 33 of 2008, especially article number 7 is discussing that if the lease contract is valid, it may not be terminated during its terms by the landlord or by the tenants. It can only be terminated by mutual agreement between both parties or by the provision of these laws, which mean by the court order or judgment according to this law. But if we can move to the article number 13 of the same law, it will define that the landlord and tenants may prior to the expiry of the tenant's contract amend any of the terms of the tenancy contracts or review the rent value or the rent amount. Maybe one of them requests to increase and the other one requests to decrease this amount. The court or the center, the rental dispute center, can look on each case circumstances and can decide to review or amend the rent according to the any request from the tenants or the landlord. But during this, we should raise some important points because we should make a balance between the landlord's interest and the tenant's interest, because these are both parties. The landlord also may have an investor, which is his financial situation is affected also by the coronavirus, as well as the tenants. Maybe his financial situation is affected due to the pandemic, and he lost his job, and he have no income to pay the rent or whatever. But we should make a balance between both parties' interests. So it's not a green light for the tenants to approach to the center in order to reduce the rent or asking for early termination of the contract. He should prove clearly his situation and that his financial situation has been affected due to the coronavirus, such as he lost his job, he cannot fulfill the contract obligation and pay the rent, the agreed rent in the contract, and he should submit to the center all the relevant documents and all the evidence which should prove that the coronavirus was the reason which affected his financial situation. That's why he wants to reduce the rent or early terminate the contract. And the rental dispute center is examine each claim on a case-to-case basis, which means the center is studying each case separately, each circumstances for each tenants and landlord is separately, so there is no basic issue. The rental dispute center and the judge should make sure first before accepting the landlord or the tenant request, to make sure first that his financial situation is affected by the coronavirus. That's it, and thank you. We can move to the other slide for the questions.
Thank you, Dr. Laura and Mahmoud, for your presentations. Very definitely current and fundamental areas that you have touched upon concerning the present status of the real estate market in the region, and hopefully the situation will get gradually better in the coming future. So on that note, we have reached the final segment of this presentation, which is the 30-minute Q&A session for this webinar. And I can see a lot of questions coming in, so we will try to run through as much as we can. So if we proceed to the first question, and Mahmoud, if I may pass this query on to you. The question says, what are the ways to handle check bounce cases or tenants absconded, particularly legal remedy, and how effective it is in the current business environment?
Thank you, Efra. This question is a popular question regarding the rental bounce checks, which mean that the landlord submit the rental check on due time, and he found that there is no sufficient funds in the tenant's account. So most of the tenant's contract stating that there is a penalty for the bounce checks as per agreed by the landlord and the tenants. This penalty should be applied for each bounce check. The other part of the question, what if the tenants disappeared, and what the landlord can make in this case? So if he wants a quick way or a quick solution for this, as all of us know, the bounce check can be submitted to the police station by filing a criminal complaint before the police station, and that procedure may lead to a travel ban against the tenants. This is the quick solution. Just if the tenants disappear, the landlord makes sure that he will not leave the country and he will lose his due amount. Then the only way for the landlord to recover this amount or to get back his apartment is by approaching the Dubai Rental Dispute Center by filing a claim requesting to the tenants to pay the due rent amount, also request to terminate the contract due to the negligence of the tenants to pay the rent amount in due course, and also he will ask the center to evacuate the apartment and deliver it to the landlord again. This is the normal procedures for the bounce check and for the filing a case before the Dubai Rental Dispute Center.
Thank you, Mahmoud, for providing elucidation around that. So the next question that has come in is in regards to rental contracts, and Mahmoud, I would like you to address this query to you as well. The question is, besides temporary rent reduction, are there any other terms that I could negotiate with my landlord in my rental contract for a temporary basis?
Thank you, Efra, again. And for this question, it's the tenancy contract is as we said before, is normal contract between both parties. So they can agree both on any condition they want if this condition does not violate the public order or the law. So any condition they want to agree on it, on the contract, they can agree together.
Appreciate that, Mahmoud. So we received another inquiry that is regarding financials. So Dr. Laura, if I may pass this question on to you. The question is, we were supposed to form an owners board and submitted applications to RERA in February 2020. Till now, we have received no answer. The manager informs us about financials, never submits any proofs on how the funds are spent, and refuses to show any bank statements for the last 10 years. How can we terminate the manager or force them into transparency?
Oh, thank you, Ifra, for the question. It's a good question, though. It's not the first time for us to hear about such things happening. So obviously, the Owners Association are regulated and are an outgrowth of the strata legislation, in particular Law 26 of 2007. as I understood that there's a problem with the manager of this owners association. Aside from the manager, the owners association should have actually a board of directors who would be able to audit in part the activity of the owners association. And of course, it would be important for us to know whether this owners association has a manager which is from a specialized company from outside, or it's one of the owners of the units in that particular building. In order to address this situation, yeah, it can be done through due diligence, or if this is not working, via complaining to RERA, and in the last case scenario by going to court for various, let's say, claims, given the nature of this case. And these claims can range from civil claims up to more severe criminal cases if we are discussing about cases of fraud or misappropriation of funds or embezzlement or variety of types of things that can happen. So yes, the situation is solvable. So I do hope that this responds to the question that we have received from our participants.
Thank you, Dr. Laura, for the comprehensive insight. So actually speaking on the topic of finance, we have received another question regarding refunds. So Dr. Laura, if I may request your input on this question. The question is, could I obtain a refund from a delayed off-plan property?
Thank you again, Ifra. A very difficult question, yet the most commonly asked question in the market. For this kind of situations, there is, I would say that us as lawyers, we cannot give an advice fitting all situations. It's not possible. Things are happening on a case-by-case basis. First of all, it depends on how the sales and purchase agreement is made. Secondly, it depends a lot on the nature of the delay, whether, let's say, the developer has otherwise complied with their obligations as per the SPA. It depends whether the developer has, for instance, registered the unit in Uqud, otherwise the SPA becoming null and void. So there are many variables that we can consider here. In case, let's say in a simple situation where indeed the property is rendered as delayed, yeah, this delay is usually ascertained via a court order or at points by an arbitral award. So in order for, let's say, an investor to claim the full refund back, yeah, this is usually happening through court or through arbitration bodies. I'm not saying it's not possible, but it depends on a variety of variables that apply in the SPA, because from our experience, we have seen a lot that clients confuse the anticipated completion date with the actual completion date of the property. From this point onwards, these are not one and the same thing. Yeah, the anticipated completion date is an estimate for which a developer cannot be held liable, whereas the actual completion date, yeah, is usually set in the off-plan SPAs at a certain distance in time and can be prolonged in order to grant some flexibility for the developer. So as long as the developer is inputting and working in the project, yeah, even if it is after the anticipated completion date, it is unlikely that the court is going to determine that that developer is actually delayed or in delay. Now, obviously, we've seen contracts and contracts. Some SPAs are coming with no penalties for the investor. Some grant penalties in favor of the investor in case of delays. So it is possible that in a case of delay, yeah, the investor to be qualified only for the penalties, but not to terminate the contract. So to give a clear-cut answer, it'd be very difficult. So things are going to be settled on a case-by-case basis. For this particular reason, Whenever an investor is in a situation of this type, it is advisable for them to look for specialized advice, because not everything that is in the contract should be authoritative in between the parties. As said, the market in the real estate of plan is highly regulated, and we would say that, I don't know, we had cases where for a small provision in a contract, it costed us 3.5 years of litigation. And we've seen cases like that and situations like that. So in principle, yes, it would be possible, but again, depending on these conditions that we have highlighted. So that would be my answer.
Thank you, Dr. Laura, for the clarification. So I can see a new question coming in, which is concerning rent reduction, which I would like to ask Mahmoud. The question is, how do I request for a rent reduction or a deferral on the next rental check? Can I negotiate this with my landlord before going to the RDC?
Thank you, Efra, for this question. And of course, you can negotiate and you should negotiate first before you went to the rental dispute center. You should negotiate first with the landlord. You should discuss with him. You should explain to him the current financial situation which you are facing, and you can ask him for reduce the rent amount or postpone the next due check, but he may accept this or may refuse it. In case if he refused your request, you have the right to go to the rental dispute center to file your case seeking or asking for reducing the rent amount which agreed previously in the contract. But I will recall this again. You should convince the judge and submit to the court all the relevant documents and evidence which prove that your financial situation is already affected by the coronavirus. Thank you.
Appreciate that, Mahmoud. So Mahmoud, another question which I would like to address to you regarding extension is, if my lease is up for renewal, is there any possible way of applying for extension?
Thank you, Efra, for this. And the question is not totally clear, because there is a difference between the renewal and extension. The renewal, you want to renew the contract for other period or similar period like the previous contract, but the extension is only a request for 1 month or 2 months more extension for the old contract. So the extension is okay. You can negotiate with the landlord and seeking for extension of the contract for 3-4 months, whatever you want, and he can accept this, or otherwise he can say, no, please, if you want, I can't accept the extension. Only if you want to renew for other period, we can make a new contract or renew the previous contract. And the renewing of the renewal of the tenancy contract is discussed clearly in the law number 26 of 2007, which amended by law 33 for 2008, regulation the relation between the landlord and the tenants. So it's clearly the procedures for renewing, which mean that if the tenants did not want to renew his tenancy contract, he should notify the landlord before the end of the contract within 90 days, which means 3 months before the end of the contract period. The tenancy contract, the tenants should notify the landlord that he will not renew the contract. He will not willing to stay more at this property. If not, and the terms of the contract has been, the period of the contract, sorry, has been ended without any notification between both parts, which mean that the tenancy contract has been automatically renewed for the same period and conditions. Thank you.
Thank you, Mahmoud. So, Dr. Lara, back to you. Could I ask for your input regarding this query? Do you think it would be advisable to purchase property that has not received an Uqud certificate yet? The developer states that they will.
Thank you for the question. Indeed, the Uqud certificate is important, but what should the parties understand from the Uqud certificate is that it is a registration in the interim real estate registry. And this registration is not permanent, is interim, is transitional for the time that the property is executed. Why? Because the investor, the buyer, is buying a property which is yet to be completed. It's a good that would come into existence in the future. So once the property is purchased off plan, it is very logical that is yet to be registered by the developer. The developer would register the property in the Uqud in the name of the buyer. Once they have, let's say, a booking form signed or a reservation form signed or the SPA signed. Otherwise, if this Uqud registration is not happening, then the investor, the buyer, has the right to claim the nullity of the contract, therefore being refunded all the amounts paid back. But in general, I think all the developers in the market work with Uqud registration. So I wouldn't see it necessarily as a matter of concern if at the time of purchase the Uqud certificate is not there. The Uqud certificate is actually in time happening after the developer and the buyer have signed a contractual document, as said, booking form or SPA. So it's not necessarily a matter of concern, just to respond to the question of the participant. Thank you.
Thank you, Dr. Laura, for the valuable insight. So speaking about awareness, I can see another question regarding project and installments. So Dr. Laura, I would like to ask this question for you. The property developer has cancelled certain projects which were agreed upon before coronavirus. However, due to the pandemic, the project has not progressed at all and we are still paying the installments. And for certain projects, the developer has not informed that they have been cancelled. Would it be possible to obtain a refund from the developer in both scenarios?
So yeah, thank you for this. The question is yet to be very clear, but we are seeing here two different legal matters. Number one is cancellation of projects. Number two is an alleged delay in projects. Now, for the cancellation, as said, even within the webinar presentation, it is not sufficient for a developer to say that we cancel the project. It is for RERA to determine, based on the development of that project, if it is cancelled or not, because RERA has a variety of tools to determine that, whether, let's say, the developer did not commence the work to do their gross negligence, or the developer is yet to obtain the approvals necessary for the project. So these are, or for example, there are cases of mismanagement in the escrow account of the project. So in general, this kind of situations led the project to become cancelled. And if the project is cancelled, then definitely the buyer, the investor, would be refunded for the amounts paid from the escrow account, according to the procedure set in the executive resolution, as we were just discussing. But again, we should not consider a project as being cancelled just because it's not progressing or because the developer is saying we may cancel it. We we cannot be, let's say, legally certain of that unless the decision of cancellation exists in with RERA. The liquidation report is done by RERA, and based on this procedure, the liquidation or things associated with the liquidation can be carried out through the Dubai courts. So conclusively, cancellation of the project is not something to be decided in between the parties. Cancellation of the contract is something else. And if, for example, in this situation, you have a project which is not progressing, is delayed, and now we are going to the second part of the same question. So if the project is delayed, yeah, again, we may presume that the developer is in default, but again, in issuing this statement, we would need to take into consideration, again, all the things that we have highlighted before. The SPA, status of the project, anticipated completion date, the final completion date, if the developer is, let's say, acting in consideration of the SPA or not working at all, yeah. So in principle, yeah, we issued this thesis before that the cancellation or the termination of an SPA may give this benefit to the investor, but not in all cases. So there are many situations where we've seen, yes, the investor claims that the developer is in delay, they claim for penalties, they claim for that, but in reality, when they're going to the court, they come back empty-handed. Yeah. So as said, we have to be cautious in approaching this kind of situations, and again, to make a very clear differentiation in between a cancellation of a project, which is, again, public order regulated by the government, and delays in the project, which are of a contractual nature, can be discussed or ruled over in the court of law or by the arbitration body according to the SPA at issue, but again, within the limits and within the environment created by this applicable regulation, which is, as said, quite comprehensive. So I hope that this responds to the question that you have received, Ifra.
Thank you, Dr. Laura. Appreciate the clarity provided towards both the scenarios. And we've just received another question, which I would like to address to Mahmoud. The question says, in light of the COVID-19 situation, before getting into a new tenancy contract, what are the key terms that as a tenant I should look out for?
Thank you, Efra, for this question. The tenancy contract is a very simple and standard contract issued by the Dubai Land Department. The standard terms and conditions include the contract period, the rent amount, the security deposit, and additional condition which most added by between the landlord and the tenant is the penalty for delaying on pay the rent or bounce checks. So as a tenant, you should study carefully your obligation and your financial situation before signing this contract, in order to make sure that you will fulfill your obligation according to the contract. I can't give any specific condition for the tenants to take care about the contract, but he should by himself know exactly his financial situation. He is able to pay the agreed rent amount in due time. He can fulfill all the obligation. If yes, he can go ahead and sign the contract, and if not, he can search for other property or apartment with less rent, or agree with the landlord with some condition reducing the rent. That's it. Thank you, Efra.
Appreciate that, Mahmoud. Certainly significant pointers that you have stated that we should look into regarding tenancy contracts. And speaking about tenancy in general, I've just received another question which I would like to address to you, Mahmoud. Which are the risks that as a landlord I currently face when renting out an apartment, such as tenant rights to delay payments, cancel contract due to COVID-19 situation, job loss, etc.?
Thank you, Efra, for this question. We should mention that no one can enforce the landlord to keep the tenants who not paying the rent in his own apartment, which means the landlord have all the right to approach the rental dispute center in order to ask terminate of the contract and evacuate the apartment if the tenants did not pay the rent in due time. So let's be clear, the landlord is investor, so he should have the risk. He cannot anticipate what's going on by tomorrow. I think in case any negligence or not doing the obligation from the tenants, the landlord still have all the right to approach the rental dispute center to terminate and evacuate the apartment. The other side, because of the coronavirus and these things, this pandemic and all this, may he agree if he already signed a tenancy contract with the tenant and the tenant have difficulties to pay in on due time, he can negotiate with him to reduce the tenancy amount or the rent amount. Otherwise, the tenant he should go to the center in order to reduce this amount. That's it. Thank you.
Thank you, Mahmoud, for that. So just quickly, one last question which I would like to address to you. The question says, I have incurred loss of pay and I asked my landlord to reduce my rent, but he did not. So I'm planning to apply my case to the RDC. What would happen if my claim was not accepted by the RDC? How will I be able to pay my landlord full? Are there any other alternative routes that I can take?
Thank you, Efra. Look, if the landlord refused to reduce your contract, the only way for you is obtaining a judgment or a decision from the rental dispute center saying or accepting your request and reducing the rent amount. There is no alternative way to do so. The first way is amicable negotiation with the landlord. If he refused, you should go to the rental dispute center. If the rental dispute center refused, that means that you should pay the rent amount, which you are previously agreed in the contract. And we can recall in this that the rental dispute center will not accept or agreed on reducing the tenancy amount or the rent amount unless you prove to the court that you have suffered damage and your financial situation has been affected due to the coronavirus. If you did not prove to the rental dispute this, the rental dispute center will not accept your application for reducing the rent. Thank you, Efra.
Appreciate that, Mahmoud. So we just have time to squeeze in just one last final question, which I would like to ask to Dr. Laura. And the question is, how can I obtain a refund from a cancelled real estate project when the developer is unwilling to refund?
Well, if the project is cancelled, according to we said the RERA procedure, it's not up to the developer to grant the refund. The refund is being made through the escrow account. If the project is only delayed, yeah, we come back to the question, to the discussion that we had previously, with all the dependents that we need to take into consideration prior to giving an advice. But for cancelled projects, definitely, since the refund is happening through the escrow account and is observed, regulated by RERA and in furtherance by Dubai courts, then it's not up to the developer to agree or not to agree. The project is not in their hands anymore if cancelled. So I hope this clarifies.
Thank you, Dr. Laura, for that. So we have arrived to the end of today's session. Thank you, Dr. Laura and Mahmoud, for answering those questions. And as informed earlier, that due to the time constraints, we might not be able to answer all the queries. However, please do stay tuned for more information regarding the matter. With that being said, you may also send your questions to our info mail, which is info@fichtelegal.com. So just to state the important points generally as to what is being discoursed within the past hour, we talked about the rights a tenant and landlord may have in light of COVID-19, the legal concerns adjoining off-plan purchases, and the general areas surrounding rental disputes. On that note, I would like to thank everyone who has joined our webinar session today. And please be aware that the presentation slides and the full recording of the session will be published on our website later today. So do keep an eye on our LinkedIn and Twitter pages for the update. So once again, I want to thank Mahmoud and Dr. Laura for presenting and answering the queries. And on that note, goodbye everyone, and this concludes today's webinar session.